All right, back to the video, you guys. When dealing with a commercial charge, whenever a police officer decides to charge you, he's not charging you, the man or woman. He's charging you, the insurance account, because you have an insurance bailment fund that you share with a decedent, a minor, and this minor, while the whereabouts of this minor is unknown, you are the survivor or the guardian ad litem, because you are the one who is acting as the accommodation party, signing all of the documents that are being addressed to the minor. But the minor is deceased because you're no longer a minor, are you? So, a charge or a presentment means a demand made by or on behalf of a person entitled to enforce an instrument. So to pay the instrument made to the drawee, or a party obliged to pay the instrument, or in the case of a note or an accepted draft payable at a bank, to the bank, or to accept a draft made to the drawee. The following rules are subject to Article 4 agreement of the parties and clearinghouse rules and the like. 1. Presentment may be made at the place of payment of the instruments. That's why when you go into court and, they do the indictment, okay, you're in the bank. You're in the bank at that point, but you're also in a religious ceremony taking place that you're being compelled into because you don't know no better. However, you're not supposed to go in there and you're not supposed to be practicing that Luciferian, Saturn worshipping tribunal there that you're going into under the impression that is a constitutional court of due process. And it is not. Okay? So, place of payment, the instrument must be made at the place of payment if the instrument is payable at a bank in the United States. May be made by any commercially reasonable means, including an oral, written, or electronic communication. Is effective when the demand for payment or acceptance is received by the person to whom presentment is made. So when you go into court and they say, do you plea, that is acceptance of their offer or their draft. They're drafting you right there for a performance, and you accept that performance by saying you understand the charges, because by saying you understand, meaning that you stand underneath that ruling of his private court. He has a private court, but so do you. But you have abandoned your private court and have pled into his, which means that you have pled into his jurisdiction. You have agreed that his jurisdiction is absolute and that your jurisdiction is non-absolute, because you've abandoned your post. You're no longer the postmaster. You're no longer standing on the land. You have to sit down. That's why they say have a seat. Or after they call the court, and they don't say have a seat, they say you may be seated. So at that moment, that's also a draft, but you accept it. You accept it for value. However, if you had known better, you would have stayed standing, and you would have either made a dishonor, which is not necessarily a good thing, or you could have made a negative avertment by switching the I guess the direction of the talk at that point by saying, well, sir, hey, we have some administrative issues before the court to administer. So see, at that point, now you have removed his judicial capacity. Now you've placed him in an ministerial capacity, and now he's going to be able to, render you some kind of remedy or relief, or at least address the defects in the matter, because that's what you're doing right there. You're administratively challenging, or you're administratively appealing the process at that moment by staying standing. You are, in the eyes of the judge, an American. You know what I'm saying? You're a United States national, or United States, whatever the word they want to call it now, because they keep switching the dog word. First they were saying it was a non-commercial, then they were saying it was attaining the age of majority. So I don't know. All I do know is that it's a bunch of trickery, and it's kind of messed up because it's been imposed upon people who really have nothing to do with that, and don't want nothing to do with that. But the same time, that is also a draft because people are not saying nothing, nor are they objecting to the authority or the rule. So, that's neither here nor there. A charge, like I was saying, is it's a bond. A charge is a bond. A bond is a obligation of record, meaning that there is a debt to be paid. Somebody owes somebody. All right. So let's get back to it. All right. So it must be made at the place of payment if the instrument is payable at a bank in the United States. May be made by any commercially reasonable means, including an oral, written, or electronic communication, is effective when the demand for payment or acceptance is received by the person to whom presentment is made, and is effective if made to any one or two or more makers, acceptors, drawees, or other payers. So see, why would they say something like that if it's made to one of two or more? One of two or more. Think about that. One of two or more. Why would they even be talking about one person accepting any kind of offer for two people if there wasn't two people? All right. So upon demand of the person to whom presentment is made. So when the judge is reading the charges to you, at that moment, he is now demanding payment, but you don't know this. You think that he's coming after you for crime that you have committed. But however, all crimes are commercial. See my video on all crimes are commercial. This is 27 Code of Federal Regulations 72.11. Okay, you go read that section there. All crimes are commercial. So for the purposes of what we're doing here, everything is governed by the Uniform Commercial Code, which is the supreme law of the land coming out of the Vatican. Okay, and so at the time of the Uniform Commercial Code being drafted, they had to figure out a way to switch over the world, which was now bankrupt, into a way that we can now pay, because they weren't ready to collapse the caboodle yet. So they're just trying to basically pacify it and, hold it up. So what they did was they came out with this ancient Babylonian style commercial system. So, number 2, upon demand of the person to whom presentment is made, the person making presentment must exhibit the instrument. So boom, they come out there with the bill of indictment. They show it to you. Or they show you the charges. Okay. Boom. Give reasonable identification, and if presentment is made on behalf of another person, reasonable evidence of authority to do so, and sign a receipt on the instrument for any payment made, or surrender the instrument if full payment is made. So at that moment, they're giving you the charges. You're supposed to give them an acceptance of those charges, because that, as the drawee, you know what I'm saying, you are responsible for that. You know what I'm saying? Even though you're not the surety. Okay, the surety is the account. So you want to ask them to settle the account out of whatever they're using. If they want to act dumb, then you just say, well, settle the deficiency out of my Social Security Treasury account, if you want to. Or you could just say, I'm here for full settlement and closure of the account. And once you say that, you have removed all judicial smoke screen that they have blowing right now in the air. Okay, you're gonna put him in his ministerial banker capacity as a clerk, and you're gonna order him to dispose of the matter so that it can be the proceeds and everything can be claimed back to you, or back to the trust. They must return to the trust. A full circuit must occur to zero the books. And that's what you need to do, is you need to zero the books, because right now, as it stands, is you have all of this debt on the public system via all of these contracts that you have been signing all of your life, and have been creating commercial events and commercial instruments that have been used, whether or not you used it or not, they still have been used for profit, gain, and quite possibly tax evasion and racketeering. So you got to catch these folks, and when you do catch them, make them give you a W-9. Anybody you pay, make them give you a W-9, and make them certify their status as a government, and make them certify their status as a non-profit organization that is not liable for the taxes. And you will commonly find out that majority of the people out there that is charging you are actually not tax exempt organizations. They are profit organizations, and because of that, you have a right of discharge. You cannot be compelled to perform. Okay, so that's what they're doing. If you don't know this, then you just agreeing. So number 3, without dishonoring the instrument, the party to whom presentment is made may return the instrument for lack of a necessary endorsement, okay, or refuse payment or acceptance for failure of the presentment to comply with the terms of the instrument. So for failure of the presentment to comply with the terms of the instrument, in agreement of the parties or other applicable law or rule. So what does that mean? I don't know, because I never heard it like that before. But I'm pretty much getting off of number 2, which is the one that has me perplexed right at this moment. It says refuse payment or acceptance for failure of a presentment to comply with the terms of the instrument. So the presentment and the instrument are not the same. The presentment is the action of, I guess the action of soliciting, or the action of, I guess the draft. You know what I'm saying? The all rise, right? That's a presentment. How do you plea? That's a presentment. Bill of indictment. That's a presentment. Okay. Is made. So the party to whom presentment is made may treat presentment as occurring on the next business day after the day of presentment if the party to whom presentment is made has established a cutoff hour not earlier than 2 p.m. for the receipt and processing of instruments presented for payout or acceptance, and presentment is made after the cutoff hour. Okay? So that's what the charges are dealing with. And if you are told that you have been charged, I will be, if I were you, I'd be searching for ways of discharging court charges, ways of discharging court cases. You know, look that stuff up on Scribd or Google or Amazon. You know what I'm saying? Or go to my website. I got plenty of awesome softwares. They got books and resources on them and stuff like that. But just check it out, you guys. Find out what a charge is. Now you know.